first thing I want to talk about, again, is just to remind you about some useful websites in connection with conveyancing practice. So they're all on slide there. Copies of the slides can be made available to you. And of course, you're entitled to a copy of the recording if you wish it, if you miss anything that we're discussing as we progress. So what I'd like to do, if I can move the next slide, and I don't seem to be able to do that, which is strange. I don't know why. If we could go to the next slide, I'd be interested to explore. Here we are, topics. So the first issue is this issue of foam insulation. I forget where I was. I think I was in Ashford in Kent or somewhere down there recently, and someone came up to me with some problems relating to foam insulation. What was happening is that the client was selling the property. The property had been recently insulated with foam, and a surveyor had come out to value the property and survey the property and said, hey, there's an issue with regard to that foam insulation on the basis that it could rot timbers, or that it was suspected of rotting timber. Spoken to a few people after that, and some people are encountering that sort of problem. Others are saying that it isn't a problem, in that if a surveyor or valuer knows what they're talking about, the foam insulation issue shouldn't develop into a rot problem for timbers, etc. I just wondered if anyone's encountered any problems or any issues with it. Because, as I say, this lady that was talking to me about it said that she'd had one transaction, then another 2 transactions that followed with the same issue. And I was speaking to practitioners after that who were saying, well, they'd encountered the problem, investigated the problem, and then identified that it was a problem with valuation and surveyors, not a problem with the property itself. Right. We've got some people. Had a client have his roof replaced to get rid of the foam before selling. It cost a lot. Debbie, this is the point I'm getting, right? And again, the same thing, Andrew, that's interested. And we've had the spray foam and couldn't get a mortgage, right? Okay, so it is a problem, isn't it? And someone was telling me that some studies had been done, and in fact, it wasn't a problem. So you have this debate. You have some people saying, right, get it out, otherwise we're not going to lend on it. And we've had other people saying, well, no, in fact, it's not a problem. I think it depends on the type of foam, doesn't it? Okay, right, now let's just have a look. There's a great series of comments here. Hi, Mark. Structural issue. Lenders are concerned that insulation doesn't allow the timbers to breathe, which could cause rot. 2 types of insulation. Latter is stated to be the worst, closed cell. Further research required. No one prepared to fund it. Lenders are concerned the insulation, etc., doesn't allow timbers to breathe. Yeah, got that. Owner cottage chose how the tiles removed. Did remove the timbers were in a poor state of repair. Okay, thanks for that. So it is an issue for us. Zara Nationwide made a speech. Yeah, I suppose, yeah, the problem is it's undercover, and therefore you don't know what damage is being done. I think as well, I don't know why I'm getting another slide on my screen and me twice, which is very unsatisfactory. I don't know if we can deal with that and sort it. Thank you. Yeah, so all right, one, it might be prudent if we're acting on a sale just to ask the question about whether foam insulation has been installed or not, perhaps to preempt issues. And it might also be useful from a buying perspective, again, just to highlight to the client, look, this might be an issue or a problem for you. It seems to me that we don't know the extent of the problem, or we don't really know if there's a problem or not. From what Mark is saying, certainly there's a potential problem. It depends on the type of foam that's being used. And my guess is that if it is causing timber to rot, it is going to be a medium to long-term issue that needs resolving. Now, I think it might have been the Conveyancing Association or someone I think looked at this, and there was sort of some clarity provided on this subject. Zara, shouldn't the survey be advisory on it? Well, yes, it should. Yeah, Lauren, I think we are, but I think what we do, just draw it to your client's attention that, look, this may be a problem, rather than waiting till the problem reveals itself. Okay, that's with the step. So I think what we can do here is say, look, let's have a watching brief on this and just be aware of it. Are they marked? So you still get a grant to get it fitted, and then everyone's saying, crikey, you might need to get it out again. Wow, that's interesting. It's a mess then, isn't it? It's a real mess. Be alive to it. It's obviously an issue. Mark has obviously, from personal experience, seen it as an issue, as have some conveyancers in connection with clients. Again, you're not an expert. You can't be an expert. All you can do is draw to your seller's attention. I think, hey, look, if you've had foam insulation installed, have you got documentation relating to it so we can see what it is? Number one. And number two, hey, there might be an issue that causes a problem. Andrew, I think there are some lenders that will lend and others are adopting exactly that stance that you mentioned. Okay, right. The next thing I've got to talk about is adverse possession. And there's an interesting case that I've just done a report on. And what happened in this case was there was an argument between neighbours about an adverse possession claim, a dispute about some land that had been taken over some considerable time in the past by a neighbour's predecessor in title. And the guy that bought the land that was subject to the dispute made a claim for adverse possession relating to it. And he made the application, the neighbour objected, and of course, if that's the case, you've then got 3 grounds to proceed. Just an equitable, that you acquire possessory title, an estoppel arises, generating an entitlement to the land, or thirdly, where there's neighbour encroachment, you had a reasonable belief in the land, that you owned the land. Don't know if you saw this case, but what happened was that it went to first tier tribunal. So the land registry had an objection to the adverse possession claim. As they do, they refer it to first tier tribunal. Matter went to first tier tribunal, and the first tier tribunal said, hang on a minute, you've got to have a reasonable belief that the land belonged to you. Okay. The fact that you're told by a neighbour that they sort of acquired the land or occupied the land a number of years ago, that they moved a fence and dug a pond, is not sufficient to give you a reasonable belief that the land belonged to you. The first tier tribunal, in essence, was saying you need more than that. You need a letter from your solicitor or conveyancer at the time to say, well, given that, you can claim adverse possession or something of that nature. But all you had was this sort of evidence of a chat between the applicant and their predecessor in title about what had happened some years ago in connection with a portion of land where a pond was constructed, a fence was erected, and from then on, the predecessor in title sort of treated the land as their own. So first tier tribunal says not enough to have a reasonable belief. Upper tribunal, whilst challenging and questioning the applicant and the credibility of the applicant, which was interesting, also said, well, hang on a minute, it's not just what he said, but it appears that on the ground there's a fence, the land has been treated as it belongs to the predecessor in title, the predecessor in title has excavated a pond, so it's not just words, there's conduct alongside it, and that is enough. So it's a really interesting case to show you this concept of what a reasonable belief in ownership amounts to, or what is required. And all I can say from that case is that the bar isn't particularly highly set. Just while I'm doing that, I'm just noticing Andrew's just said something again about our foam insulation point. Instead, still actively promoting selling it in some instances, yeah, with a product causing survey issues. It is, isn't it, Andrew? And you'd expect someone to say, hang on a minute, stop this. But I haven't seen anything in the press. Has anybody else? I haven't seen anything in the press. Anyway, as for that case, I was going to dig the name out for you. Just bear with me and I'll find it. Where are we? Here we go. I will look at it because I've just done a report on it. Bear with me and I'll find it for you. While I'm doing that, oh gosh, where is it? Always the case, isn't it? When you want something, you can't find it. And I was just looking at it earlier this morning. Bear with me. While I'm digging that out for you, I want to talk a little bit about SDLT and SDLT issues. What is causing headaches for you with regard to SDLT? Is it sort of mixed use properties? Is it sort of granny annexes and this sort of thing? Or is there something else that's really causing you problems at the moment? Is the question that I'd like to pose on SDLT. Anyone got any views, any problems, any issues? In the meantime, I'm trying to find my case. And I can't. This is not good news. SDLT. A number of things to note. One, if you're dealing with a complex transaction, you can get specialist advice and assistance with regard to SDLT. Two, make sure that you are relying on information from the client and the client is aware of that fact. Understand and appreciate that from the client's perspective, the client needs to know why you need information and how that is going to be submitted to HMRC. Right, yeah, multiple dwelling relief, Joe, for annexes, a real problem, isn't it? So, Joe, how do you deal with it? So let's assume I'm a client and I'm buying a property and there is an annex or something that could be perceived to be an annex. How do you deal with it? So I'll come back to that, Natasha. That's interesting. And Zara, there are, yeah, getting higher rate refunds. And there's also people looking at negligence claims, isn't there, at the moment? So I want to deal with Joe. So, Joe, multiple dwelling relief for annexes is an issue. How do you deal with it? What do you do? Do you have a questionnaire for clients? Do you look at the agent's particulars and see if you can sort of decipher what the position is with regard to an annex or what else? So I'm just waiting for Joe. Can anyone else help us with multiple dwelling relief, how we deal with it? Natasha, you're certainly entitled to ask an accountant for input. That's not an issue. That's perfectly acceptable. And again, important to understand that it's understood that SDLT can be complex. What would be the position if you had a client who said to you, look, my accountant is saying there's a scheme that means I can avoid SDLT liability or limit it. What would you do in that context? If a client's saying, look, I've got this Wizzo scheme that means I'm not going to pay SDLT or it's going to be reduced. Yeah, raising inquiries, view agents' particulars, yeah, advice from a tax advisor. Okay. Yeah, just 2 seconds. There's lots of questions. I thought there would be on SDLT, to be honest with you. Let's have a look. So Joe's saying, yeah, raise inquiries, view agents' particulars, get specialist advice. You can, of course, get advice yourself, Joe. If it's complicated, you know, it's accepted now. I think the CQS suggests that if it's a complex matter, you tell the client it's complex, get specialist advice as a firm, rather than simply saying to the client, you know, you need to go off and get specialist advice on it. Okay, yeah. So, Lauren, uninhabitable property. How would you deal with it then? If we've got or we're buying an uninhabitable property, you've seen the HMRC guidance on this, have you? So do you just look at the guidance, or what sort of evidence would you have on your file or ask your client to collate that would be evidence that this is uninhabitable? Because it's always a question of fact, isn't it, Lauren? And Mark, yeah, not suitable for users dwelling on the fact that clients find it difficult to accept. It's a high bar to get over. Yeah, it is a high bar, isn't it? The HMRC are clamping down on this one. So Mark, how do you deal with that? And Lauren, I'm interested to see what you've got to do. And Mark, Robert, hi, Robert. I'm going to come back to your 2 properties in a moment, if I can. So I'm going to deal with that in a second or two. Right, so I'm going to look at Andrew's question, and I'm coming back to you, Robert. Yeah, the tax position. Thanks, Andrew. You're going to put an HMRC calculator on your website. Yeah, you've got to watch transactions in Wales at the moment. Again, this is one of the things I'm going to mention about the Building Safety Act, Andrew. Andrew, can you make sure that your website address is put in the chat box so that people can be aware of that? That would be really useful, please. Right, Robert. Owning two properties on a temporary basis. Right. Anyone help Robert with his question about SDLT and two properties? I'm still trying to find this case while everyone else is doing that. As far as I understand it, Robert, there isn't a sort of hard and fast rule about this issue of two property ownership and about the potential for capital gains tax. It's a really complex area. Right. Yeah. Christopher, I can certainly say on your uninhabitable property, lack of heating won't be enough. I've seen that before. I think the HMRC want more than that. So yeah, I'm going back to Robert's question. I'm just looking at some of my notes on that, if I can find them. Because you are allowed to have a situation where you own two properties, aren't you, on a temporary basis? And I know there's a rule as to time, but I know that can be extended. So I'm just trying to find it, but I'm interested to know if anyone's got that offhand. And I'm giving up with regard to my case on adverse possession at the moment. Right, Robert, let's have a look. I think if you were to let out the old property a year or so before selling, there might be an issue, Robert. And there's something in the back of my mind that just sort of triggers that. I don't know if anybody knows. I'm just looking for HMRC guidance at the moment. I'm struggling with that now because I've got a problem with internet. Yeah, I think the point, Robert, and that's what was in the back of my mind. You can claim an SDLT refund, can't you, in if you sell the property in 3 years. So you pay higher rate SDLT, then you claim it back as a refund if you sell within 3 years. Their rules differ if your property was sold before 28th of October 2018. That's not going to be an issue. I've seen negligence claims, Robert, where people have not advised the client about the ability to claim back. And I think HMRC have a discretion, don't they? Where we're beyond the 3 years. And just looking at it, Robert, I think I'm wrong. I think you could let it and the letting wouldn't cause a problem. Just looking at the guidance again, I think I'm wrong. I think you could let it. That wouldn't be a problem. Right, let's have a look at Andrew. Yeah, you've certainly got that, Andrew. That's a good point, isn't it? You've got to be careful about recovery. So you pay it and then claim it back, aren't you? And that's interesting. Let's just have a look at Andrew here. Andrew's got a great point, aren't you? Maybe two opportunities to recover and not pay the additional SDLT. You're renting out the original residence as a buy-to-let. Two, you later sell and reclaim. Is that right, Andrew? That's possible. That's interesting. Harriet. Yeah, certainly, Harriet. HMRC, you've got to look at things on a case-by-case basis. You can't assume that because in the past something has been accepted by HMRC or it hasn't been accepted, you can't state that's a precedent. I think that's the important thing. Right. Okay, thanks, Lauren, for that. The guidance, that's great. Yeah. One thing, right, with all of this, it's very important. Do make sure that whenever you're dealing with this, make a detailed note on file what you've decided and why, okay, and where you've sought advice or guidance. I can't emphasize how important that is, because if HMRC come and have a look at you and they can see that you've tried and you've made a mistake, but it's a reasonable mistake to make, then you'll be looked at differently as if you haven't got any evidence on file whatsoever. Okay, thanks for that, Harriet. And to be honest, SDLT is so complicated, it's ridiculous. And as was mentioned, when you start dealing with Wales, the position becomes radically different. So I was saying about what happens if a client comes to you and says, hey, I've got this idea about avoiding SDLT. My accountant says we can do this, that, and the other. What do you do in that situation? I hope what you do is say, look, I can't act for you in anything that would constitute evasion unless you have a scheme that has been approved by HMRC or they've seen it and said, yes, you can do it. I can't act for you. I think it's so important to do that. I've seen loads of schemes that are adopted, okay, HMRC don't see it and give prior approval or don't comment on it. You then use the scheme, don't pay SDLT, HMRC look at it and say, you can't do that, and what you've done is evasion. So there are fines and penalties and all that goes with it, as well as the liability in connection with unpaid amounts. And remember, HMRC can always look at a transaction and say, right, what you've done has reduced or avoided SDLT. We're entitled to undo that transaction and look at how it should have been on the basis that you're paying the full amount of SDLT. So they won't say, oh, there might be another route that can reduce your SDLT liability. They'll just say, no, you can't do that. This is what you should have paid, which is pretty scary. So please, 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 with SDLT, when you're onboarding the client, when you're scoping the retainer, tell the client about SDLT, tell them about the submission of an SDLT return, tell them about anything that's unusual with regard to the property that would warrant further investigation or specialist advice, explain that there'll be a cost relating to that specialist advice, and highlight to the client the fact that when you submit a return, you'll be submitting information from information that the client's given to you. So if that information is wrong or defective, the client's in the firing line, not you. So important. And always watch where additional SDLT returns are required or where there's an opportunity to reclaim SDLT. I think it was the Legal Ombudsman's website that gave an example of a number of complaints being made against conveyancers with regard to SDLT issues. Most of them were situations where SDLT hadn't been paid or the correct amount hadn't been paid, but some of them were complaints because it was possible to reclaim SDLT or it was possible for an additional return to be submitted that hadn't been submitted that led to problems for the client. So always watch out that. Yeah. Yeah, Lauren, I think that's a great way of putting it. Always the case, if it's not on the file, it didn't happen. And I think the other thing is that, again, Harriet mentions and Andrew mentioned too, the fact that what you've got to do is it's worth looking at previous cases, looking at HMRC guidance, etc., but just always remembering that every case is looked at on a case-by-case basis. Just because HMRC allowed X doesn't enable you to say that they'll enable X in a 2023, guys. So watch out for that. The last topic that I've got, as Robert alluded to, is the Building Safety Act 2022. I was at a conference yesterday where there were mountains and mountains of questions, as usual. Some interesting things. Number one, landlords are really waking up about the Building Safety Act now. I had an email last week, and it was a landlord direct to me with, oh gosh, about 7 or 8 properties in central London, and mountains and mountains and mountains of questions. You know, does the Building Safety Act apply to this building, which is all commercial? Answer, no. Does it apply to this building that contains 2 residential units? Answer, yes. Does it apply to this building, even though the residential elements are let on ASTs? And my answer there was, the Building Safety Act will apply to those residential units. Some of the Act won't apply. The Schedule 8 protection with regard to service charge, etc., won't apply because they're not residential long leases. No need for the production of a landlord certificate or any worries in connection with a leaseholder deed of certificate, but the Act does apply to that building. Further questions about what is the position if flats in a building are let on residential long leases, but are let to companies, and those companies are associated with the landlord. Well, again, in those circumstances, the Act still applies, and potentially those leases could be qualifying leases if the company is a separate entity to the landlord, this sort of thing. I'm going to go back to Andrew a moment. Andrew, yeah. Yeah, this idea is that it is a discretionary tax. Is a good point, Andrew, and thanks for giving us your contact details. That's really useful. Yeah, Zara, I'm going to deal with this, okay? Information and misinformation about the Building Safety Act. Some solicitors are not even asking about how many floors in a building. I've been working on this just recently, Zara. What I think a conveyancer acting for a buyer has to do is as follows, okay? I think where a leaseholder, where the seller or the estate agent is saying this building is more than 11 meters or more than 5 stories in height, I'm going to report that to the client and say, well, this is what I've been told, but I can't verify or confirm its accuracy. If a landlord is telling me it's more than 5 stories and more than 11 meters, and therefore the Act applies, same principle. Hey, Mr. Buyer, it would appear that this is a relevant building for the purposes of the Building Safety Act. Where I've got a building that's more than 18 meters in height, remember the landlord or the relevant person is required to register it with the building safety regulator, in essence the health and safety executive, and therefore where it's been registered, again I'd be saying to a buyer client, this building has been registered as a building with a height in excess of 18 meters, therefore I'm assuming that it's a building that's more than 11 meters or 5 stories in height. So I think that's how you deal with the height issue. You just say to the client, I've got this external information that leads me to believe it is, but I can't verify it and have not verified it. Okay. So just going back to that, that's the first thing on height. Okay. The next thing that I want to mention is that a landlord certificate is a complex piece of information. It will contain information about the financial circumstances of the landlord, its financial status. It will also contain construction issues. So you as a conveyancer cannot advise a client or indeed a lender or verify that the information in the landlord certificate is correct. All you're hopeful of is that the landlord has been sensible in producing a landlord certificate and has taken the appropriate advice or has the appropriate data and information to hand that can produce a landlord certificate that contains the correct information. If a landlord certificate does not contain the correct information and is defective, it's not a valid landlord certificate. And if a valid landlord certificate isn't served, as prescribed by the regulations within 4 weeks of request, 4 weeks of notification of sale, 4 weeks of incurring an expense that would be a remediation cost for a relevant defect that is caught by the Act. If the landlord doesn't do that, then he can't recover the historical costs that he should have been able to recover. But what a landlord can do is a landlord could issue a new landlord certificate on the basis that tomorrow he has a surveyor in that says, oh, your building's full of the problem concrete and is at risk of collapse, and therefore you need to take some urgent measures to prevent that. The landlord could issue a new landlord certificate for those works, serve it on leaseholders, and recover the remediation cost subject to whatever Schedule 8 protects for qualifying leases. Yeah, Zora saw that. Make qualifying leases non-qualifying once the remediation work is done. In other words, you get one hit with regard to remediation for relevant defects, Zara. That's what I understand it to be. So if the remediation work then requires remediation, you're not protected under Schedule 8. I think that's the case. Zara, I'm going to look at your other point. Had a lady bang a 4th floor flat. When I saw the particulars, the ground floor was blocked off, raising the story level. Yeah, I mean, that's an issue. So, Zara, that's the point I'm making. It's not for you to say this is 5 stories or this is an 11-meter plus building. You know, there might be issues there that you're not aware of, and therefore you can't do anything other than to say, I'm told that this is the case, and therefore I'm assuming if that is the case, this is a relevant building to which Schedule 8 applies. But theoretically, the Building Safety Act applies to any building that contains 2 or more residential units. Mark, I'm going to have a look at your problem. Yeah, I'm getting a seller or landlord to confirm your suspicion. Well, okay, in that situation, Mark, I think what you've got to say is it reasonable to suspect? So on what grounds are we saying it's not more than 11 meters high? Is the estate agent saying that's the case? Is the landlord saying, you know, where are we getting that information from? If it's just us looking at some agent's particulars, I think we've got to be cautious. And that, yeah, as to what remediation work is, again, right? I was talking about this yesterday. If you look at the TA7 and you look at section 11, it asks the seller to confirm if they're aware of any remediation works being undertaken by the landlord. Remediation works as defined by the Building Safety Act. Now, how on earth can a seller verify that unless the landlord has said to him or consulted upon works of that nature? Okay. What I'm saying to practitioners is with a TA7 form, before you give it to your seller client, you've got to provide the client with information as to what remediation is or what a landlord or leaseholder deed of certificate is, because if not, they're completing section 11 of the TA forms blind. And as we saw on the last occasion we were together, there are 2 cases, more than 2 cases, where sellers are being sued for misrepresentation, where they get something in a TA form wrong. Remember the Japanese knotweed case and the Pacifico case concerning a 2-bedroom flat. So, you know, again, with acting for a seller, there's the TA7 form. You need to understand that this is what a landlord certificate is. This is what a leaseholder deed of certificate is. This is what remediation work is defined by the Building Safety Act is. I think the other thing with regard to TA7, I don't know if I mentioned this last time, but the questions I think, are incomplete. You need to raise additional inquiries if you're acting for a buyer, such as when did the seller notify the landlord that the property was being sold, which would trigger the need for a landlord certificate, or has the leaseholder asked the landlord for a leaseholder deed for a landlord certificate, which also would trigger the need for it. You need to know when those requests were made. As for notification of sale, I'd also want to know how the landlord was notified, never mind just what was the date, because again, that might be an issue that could cause problems long term with regard to the validity or otherwise of the landlord certificate, or arguments about the landlord certificate being served out of time. The reason I mentioned the Building Safety Act wasn't to do with any of this stuff at all. It was in connection with Welsh properties. The Building Safety Act applies in part to Welsh properties, but the regulations in Wales are slightly different. For example, a higher risk building in Wales is a building that has any more than one residential unit in it, not two. And there are other aspects of the Welsh regulations that are different, which means if you're acting on sales or purchases in Wales, you've got to be so careful. One of my projects, which I haven't got time to deal with at the moment, which is on my list of things to do, is to produce some notes on Welsh properties and on the Building Safety Act and the difference between the BSA as in force in Wales and as it is in England. Yeah. Well, that's right, Andrew. On the issue of height, you're right. It's not the top of the building, it's the floor of the top floor. So you can't look externally and say where the top of the building is. Yeah, you can't tell that. And again, if you've got it wrong, you're high and dry. You cannot, I repeat, right? You cannot confirm the height of a building as a conveyancer. You can't do it. You can only say, I have been told by such and such a source that this building is such and therefore I'm assuming it is a relevant building, or I'm assuming it's not a relevant building. We're back to what I always go on about, scoping the retainer, making sure your buyer client is aware of the limitations of your role as a conveyancer. If you do that, you're safe, right? The moment you are verifying that this building contains more than 5 stories or more than 11 meters in height, you're in trouble potentially if you get it wrong. And as I say, there is a saving grace on the basis that buildings over 18 meters in height are obliged to be registered. There is a thought, and I don't know, Zara, if you've seen this, but someone was telling me that there's a thought that the height will reduce. So we might have a situation where there's an obligation to register buildings more than 11 meters in some time in the future, but at the moment it's 18 meters. And I think is there something like 12,000 buildings that are more than 18 meters in height that require registration? And of course, remember, the health and safety executive are pretending to be the building safety regulator for that purpose. And also remember, your client commits an offence if they are obliged to register a building and they fail to do so. So yeah, I'm going to try and do that, but the problem is just time at the moment. So Davina, I'll keep you in the loop. Again, drop me a note and I'll make sure that you're on the list for that. Zara, no, I don't think you are, right? I go back to first principles. As a transactional property lawyer, you're not expected to be an expert on all matters that you're dealing with. You're simply required to draw a client's attention to risk. So with regard to the Building Safety Act, what I'm saying to practitioners is this. One, I would be telling every client that the Building Safety Act has the potential to increase the cost of service charge because there is additional burdens being imposed on landlords with regard to safety management. That is particularly the case where buildings are more than 11 meters or 5 stories in height, and even more the case when a building is more than 18 meters in height. The other thing is that where a building is more than 11 meters or 5 stories in height, a leaseholder does get potentially some protection for some remediation costs for some defects, depending on whether or not they have a qualifying lease or not. The Building Safety Act also provides some protection for all leaseholders if there is a relevant building, because that protection is that the landlord is not allowed to transmit the cost of remediation for works that the landlord did that now require remediation, if that makes sense. So there's some protection under the Act, but it's not blanket protection. It is, if your lease is valued less than £350,000 Greater London, £175,000 out of Greater London, then the landlord can't transmit remediation costs for relevant defects into your service charge if you have a qualifying lease. Further, with other leases, there is a cap of £15,000 Greater London or a cap of £10,000 outside of Greater London for remediation, for service charge costs relevant to remediation for relevant defects. Again, be careful about that, because with certain higher value flats, the cap increases. And again, remember that the cap of £10,000 or £15,000 then has to be spread out over a 10-year period. So there's some protection that Schedule 8 affords. If we start talking about higher risk buildings, more than 18 metres in height, remember, we've got implied covenants in the lease on both landlord and leaseholder, additional responsibilities on landlords or others with regard to building safety management. Those additional duties and functions are going to lead to additional management costs. For buildings over 18 metres in height, there's now the concept of a building safety charge relating to that building safety management, which is out with the standard service charge regime within the lease. So there's additional cost that your client is going to pay because of the additional work that a landlord is going to be required to do because the building's more than 18 metres in height. And it could well be that any saving that is made because your building is a relevant building and you've got a qualifying lease is overrun by the additional cost that you are paying because your building's more than 18 metres in height and because the landlord is therefore required to do additional works to comply with their duties under the Building Safety Act. That's the problem. So what I say to practitioners is, when you're scoping the retainer, provide an information sheet to clients about the Building Safety Act and about service charge. Explain that the service charge obligations in a residential lease are an obligation, a contractual obligation to pay unascertained and unascertainable future expense. That your client has some protection by the Landlord and Tenant Act 85, which applies whether we're a qualifying lease or not. Reasonable service charge is only recoverable if it's reasonable. Obligation to consult, obligation to provide leaseholders with statutory notices, obligation that service charge is irrecoverable if it's beyond 18 months old. Right. Okay, Lauren, let's have a look at your question if I can. We have a managing agent going into administration in the Bournemouth area. Any advice for the freeholders and leaseholders where funds may have gone missing? Are there any protections going forward for lessees where management agents are used? Alex, I can tell you that where a landlord or an entity that's responsible for repair and maintenance of a building, a relevant building for the purposes of the Act, the Building Safety Act introduces new protection for leaseholders in the event of landlord or managing agent insolvency in that context. But as far as general protection for managing agents going off into the sunset with service charge funds, etc., then there isn't any specific redress. Remember, however, that any service charge that's payable by leaseholders is held on trust for leaseholders, and therefore disappearing with service charge monies, etc., would constitute a criminal offence. So you can have a look at the Leasehold Advisory Service website, as suggested. You could also have a look at the Association of Residential Managing Agents website as well, Alex. And if the managing agent is dealing with repair or maintenance of common parts or structure, have a look at the Building Safety Act insofar as it relates to the insolvency of the managing agent. There might be some protection there. The only caveat I would attach to that, Alex, is that not all of the Building Safety Act is in force. And to be honest, I haven't checked if the provisions relating to insolvency are in force yet. So I'm not sure. Part of me thinks that they only become in force as of either the 1st or 3rd of October. But interesting question, Alex. Thank you for that. Zara, how to dispute or query service charge? Right. Okay, yeah, I can tell you about how you do that, Zara. The Leasehold Advisory Service has guidance about challenging service charge. Remember, I repeat, service charge has to be reasonable. The cost has to be reasonable. The works that are done have to be done to a reasonable standard, and landlord must undertake reasonable supervision. If it isn't, then the service charge isn't payable. That's section 35 of the 85 Act. I think it's 85 or 87 Act, I think, Zara. Service charge is only payable and only due if a landlord has notified the leaseholder of their statutory rights to challenge by application to first-tier tribunal. Service charge is only payable, I think this is section 20Z of the 85 Act, if the landlord has incurred the service charge expense and has either notified leaseholders that it's been incurred or produced service charge accounts within 18 months of the expense being incurred. Once it goes beyond 18 months, if you've done neither of those things, the service charge is not recoverable. Davina, I'm going to have a look at your question. I'm conscious of time, by the way. I think we've got a few minutes left. Yeah. Right. Davina, our expert on this is Zara. Okay, she's aware of Lord Lytton's proposed polluter pays amendments. I think, Zara, it didn't get much further than a brief discussion. Zara, is that about right? Do you think, is that a fair way of looking at it? While we're doing that, oh, thanks, Zara. Contact Zara. She's our expert on that. I've spoken to Lord Lytton, really nice guy, heart in the right place, no real appetite from government, as I see it, for anyone to do anything. I think you know, it's a problem. Yeah. If you have a look at the Leasehold Knowledge Partnership, Zara, a lot of the cladding groups are sort of quite active on that site. You could have a look at that. Yeah, so as far as the Act is concerned, one, landlords are waking up to it, I think, and aware of just how significant a piece of legislation it is. Conveyancers, I think, are now getting to grips with how to deal with Schedule 8 landlord certificate, leaseholder deed of certificate. I'll mention something about that before I finish. And are also aware that the Act has greater implications. I repeat, over 18 metres, there are now terms implied into the residential lease on the part of both landlord and leaseholder, obligation to register, additional burdens on the landlord with regard to building safety management. Now, I was going to say about the current position with regard to Schedule 8 and landlord certificates and leaseholder deed of certificate. The more time I spend on this, the more questions I get about it, the firmer my view. I think you can act for a seller as long as you warn the seller about the fact that the TA7 form and the leaseholder deed of certificate, if they're producing it, are documents that the client is producing in isolation, and all you can do is check the information that there is produced within it against the information that you've got on file. And with regard to a leaseholder deed of certificate, you can confirm that the procedural requirements of the document, that it has been executed as a deed, could be checked. But that's all. From a buyer's perspective, I think this is the route that you need to take. Someone's put the hand up. I'm going to come to you in a moment. I'll just finish this and then we'll come back to that one. With regard to a buyer, I think that the way forward is, one, to try and make sure that the documentation that you need comes from the seller leaseholder. So I'd like the seller leaseholder to produce for me a leaseholder deed of certificate. In an ideal world, I would be really happy if the leaseholder could confirm that the landlord doesn't have a copy of the leaseholder deed of certificate and the landlord hasn't asked for it. And I would also be delighted if the leaseholder could tell me that the leaseholder has asked the landlord for a landlord certificate and the time for the production of that certificate has expired. Why do I want those things? Well, firstly, I need a leaseholder deed of certificate to confirm this is a qualifying lease. I'm parking to one side the issue about whether it's a relevant building, and what I said earlier stands in that connection. But if I've got a leaseholder deed of certificate, and I've got the leaseholder saying my landlord hasn't asked me for a copy of the leaseholder deed of certificate, and the landlord doesn't have a copy of the leaseholder deed of certificate, then the position is that I don't have to rely in the leaseholder deed of certificate on the producer of that certificate telling me who owned or occupied the property as of the 14th of February 2022. So all I have to do is look at what is in the leaseholder deed of certificate with regard to, is it a relevant lease? Was it granted before the 14th of February 2022? And is there an obligation to pay service charge within the lease? And I can check that information by looking at the lease itself. Where the landlord hasn't asked for the certificate and hasn't got a copy of the leaseholder deed of certificate, then paragraph 13 of Schedule 8 applies, the presumption applies, and I don't have to worry about ownership or occupation on the 14th of February 2022. I have a qualifying lease. If a landlord should have served a landlord certificate on me and hasn't, then the landlord can't recover against my client any remediation costs that predated that landlord certificate. So that's the route to take. Now, just have a look. Yeah, wonder why lots of blocks over 5 floors with cladding issues are zero related. It's still early, but I expect mass repossessions. Don't know the answer to that question, Andrew. Does anyone have any other questions? Yeah. The point that I would make there, Zara, is if you get the landlord's inquiries, right, again, that will give you information about what the landlord's got or not got, okay? But I wouldn't go fishing with the landlord, ask, have you got a leaseholder deed of certificate? I wouldn't do any of that. I started by asking the seller, because if the landlord doesn't have it and hasn't asked for it, then I've got some protection. Okay, yeah. If you can share the answer, Andrew, Zara, that would be interesting. Right, now, someone put their hand up. Sorry about that. So who put their hand up? Zara. Go on, Zara. We'll get your microphone on. Fire away, my friend. If you can, or have you dealt with it in the chat?
Can you hear me? I
think yeah, can, Zara. Loud and clear.
Sue's put her hand up first if you want to go to Sue first.
Who put a hand up first, sorry?
Sue.
All right, hi, Sue. Yeah, carry on. Thanks, Zara.
Hi, thanks. Sorry, I missed a bit of this conversation. I was off on a comfort break.
Yeah.
About the cladding, we had, as you may or may not recall, I work in-house for a housing association in Wales. Yes. And so therefore I've only got the one client. Bonus, sorry everybody. But I recently did a valuation for one of our lenders. As you know, they require them periodically every 3 years or whenever.
Yeah.
One of our buildings, flats above shops, which we built, came back with a cladding issue. Yeah. And the Welsh government seemed to be instructing intrusive surveys, right. And we were waiting for the valuer wanted to see it. Yeah. We were waiting for it, and they're so inundated, the surveying people, that it took about 4 months. Right. Which of course blew our valuation deadline out the water. Yeah. But pending that that report, which we're still waiting, the valuer has given a nil value to the building. Right, crikey. So that affects, of course, our our loan to value sort of thing. Nightmare. But it's the point really was that the effect on the valuation of properties and lenders' requirements, and also the fact that the Welsh government are being quite proactive about this, and they're they're the ones that are instructing.
I was going to say that, Sue. That's and looking at the regs and doing the work at the moment, it seems to me the Welsh government is saying, "Hey, look, we're going to deal with this. You know, we don't want the market to look at it. We don't want external surveyors, etc., to look at it. We're going to grab it. It's such an important topic that we're grabbing it." The interesting thing about that, Sue, is the point you just made. Do they have the resources to deal with it? Because they're going to have to outsource, aren't they? Surveys, etc.
Yeah,
and
absolutely.
Therefore, we're probably back to square one again.
Well, because we had a timeline issue with our valuation. Trying to get it done before the valuation was impossible. So the alternative was that we do it ourselves.
Yeah.
The quote that we got to do the intrusive inspection was 25,000.
Ouch. Yeah.
So, you know, we said, well, let's wait and see what the Welsh government's instructing surveyor comes out with.
Makes sense.
Still waiting. But it is, I mean, luckily out of all of the housing stock, we've only got the one with the dodgy cladding. It's a fairly new one. It's a fairly new scheme structure, but you know, it just goes to show how things have changed since the
without a doubt, so without
since a doubt, legislation, you know. Anyway, just thought I'd share that with you.
Thank you, Sue. That's really kind. Zara, over to you, and then I've got someone I want to introduce to you before we finish today. So, Zara, what were you going to say?
I won't stay all day, but if you want to support the Earl of Lytton scheme, go to buildingsafetyscheme.org. It's got lots of information there, and I know why there's divide and rule between the groups. So basically, you know, there's those that are down with leasehold, full stop, but what they don't realise is that it's a two-step process, is that we need to get the developers to take responsibility for the buildings that they've build on that, and then sort of look at leasehold issues with a view to common hold. But if they're just shouting and shutting anyone down who talks about building safety, going, you know, off with their heads, we want, you know, common hold. It's not going to work, because they will still end up at square one, being responsible for their buildings. I've been told various sources of where this is coming from. I refuse to believe it, and I still can't get an answer out of the man as to why these you know, why these people, you know, why they are divide and rule, unfortunately.
Zara, could you just put that website in the chat box, because Natasha's just asked for it. If you could do that for me, that'd be great, Zara, and thanks for that. I'm conscious of time, and what I'd like to do is to introduce a lady that I had the pleasure of meeting in an organisation, a company that I had the pleasure of meeting, Smokeball, and a lady called Rachel Holmes. Rachel, I hope you're with us. And I just think it's useful for people to understand and appreciate your sort of place in the market and what you're doing with regard to case management, etc. So, Rachel, first of all, thank you so much for coming along today and for listening in. I hope it's been of some interest to you. And I would like you, if you've got a few moments, and if you don't mind, just to introduce yourself and just to explain a little bit about what you're doing and how people can contact you. That would be lovely.
Excellent. Hi, everyone. Thank you, Ian. It's been very interesting to hear a little about the struggles and everything that, you know, conveyancing isn't just that one line, is it? There's a lot more to it.
Absolutely.
So my name is Rachel Holmes, and I am the Managing Director of Smokeball UK. Now, Smokeball is a case management system. We have been going in Australia and the USA for over 11 years now, and very popular over there, and we're super excited to be here in the UK to bring it to everyone here. Now, we do have everything from your own client intake, so that how to get the work, how to do the work, with lots of beautiful productivity tools, and then how to build the work as well. So actually all your invoicing and everything on the other end. I am very excited. This is perfect timing to have the amazing Adele Hoyle sitting next to me.
Hi, Adele.
Hi, Ian. Adele, meet Ian, and everybody else. We won't keep you long because we're all hungry. We know it's lunchtime. Adele is our Chief Product Officer globally at Smokeball. So we're very lucky to have her here today, and she just wanted to have a little chat to everybody on the forum.
Thanks, Rach. And I know we're out of time, but just wanted to sort of mention how, you know, from at Smokeball, sort of how we differentiate ourselves a little bit from the other CMS systems out there is kind of our passion for problem solving and for talking to the likes of you all and listening to your biggest problems and pain points, and then how we can look at trying to solve those problems with technology. So definitely a big passion of ours, something that we do a lot of. So it's great to hear some of the things that happened today, but we would love to hear from anyone who's willing to have a chat with us and share their problems, either current case management problems, just problems like coming to work every day. These are the challenges that I have. These are things that take me a really long time to get my job done, and, you know, help us get some insights for the UK market and how we can look at helping solve those so we can have a great product fit in the UK like we do in Australia, in the US. So I think we're going to have our details shared, so we'll be able to
please, Adele, why don't you put your contact details in the chat box there for people, and again, we'll happily share with Deluxe. We could do that now. I've just put my contact details in for anyone that has any questions for the next forum, but you could do that, Adele. That would be great, and we will share your details. And Adele and Rach, it'd be nice if you could sort of join us on future forums as well, and perhaps do a demonstration of your product. That would be really good at some point in the future.
Yeah, I would love to.
Yeah. Sounds good, doesn't it?
Okay.
Yeah.
All
Good.
right.
So what we're currently, just to give you an idea, I just didn't explain, coming to the UK, but we have actually been working for well over 12 months on localizing Smokeball for the UK market. So a lot of research has gone in, and just a little taster is what we're looking at now is we're looking to perhaps invite some firms of really good communicators like you have on your forum to just have a look at the system with us and to join a foundations group. So we can build a group of people similar to this, where people are happy to give their opinions and their thoughts, and similar to what Adele just mentioned. So if anyone's actually interested in talking to us about being in that foundations group, we'd love to hear from you. If you wanted to pop in the chat, yes, I'm interested, we will definitely reach out. Otherwise, you can email Adele or myself, and our details will come through in the follow-up email to this as well. You can also visit smokeball.co.uk. Not a lot on there yet, but what is on there is a waitlist form. So you pop your details on there and we can get in touch with you.
Brilliant. Thank you for that. Thanks, Adele. Thanks, Rachel. Lovely to speak to you both. And thank you all for attending today. A massive thank you to Stewart Title for organising this event. It really is appreciated. Stephen and Robert, thank you very much indeed for inviting me along. Thank you all for coming along. Topics for next time, anything and everything. It's great if you can ping them across to me early so I can have a look at them. I'm going to have a look at the SDLT issues that we were talking about today, because as I say, I want to try and get to provide some information sheets for you on that if I can. I'm also going to dig out that case that I couldn't find in connection with the adverse possession, because that's interesting. We'll share that with everyone that attended today as well. Thanks, Sue. Thanks, Lauren. Thanks, everyone. Have a lovely day. Stay safe and look after yourselves. Bye-bye. Bye-bye.